Hello and welcome to Grace Tutorial. In this video lecture, we will be discussing about one of the most important features of the Indian Constitution, that is the fundamental rights. Well, the fundamental rights are basically enshrined in the Part 3 of the Indian Constitution, which is under Article 12 to 35. In this regard, the framers of the Indian Constitution derived an inspiration from the Constitution of USA, that is the Bill of Rights. The fundamental rights, the Part 3 of the Constitution, is rightly described as the Magna Carta because it contains a long, comprehensive and the justiciable fundamental rights. In fact, the fundamental rights in our country are more elaborate than those found in any other constitutions in the world. If you look at the fundamental rights are guaranteed by the Constitution of India, which upholds the dignity and unity of the nation. So if somebody asks you that, what do you mean by the fundamental rights? The fundamental rights are meant for promoting the ideal of the political democracy. So this is what one of the most important definition that we need to remember. What is meant? That means why, how the fundamental rights are meant for. The fundamental rights are meant for promoting the ideal of the political democracy. One more thing we need to understand here, why the name fundamental right are given so? Yes, the name fundamental rights are given so in the way because this is guaranteed and protected by the Constitution, which is the fundamental law of the land. Since it is guaranteed and protected by the Constitution, which is fundamental law of the land, that's why the name fundamental rights are given. The fundamental also in the sense that it is very much essential for all-round development, such as intellectual development or spiritual development, material development, etc. Since it is essential for all rounds of development, that's why these rights are also known as the fundamental rights. That means you need to understand here, the rights are fundamental because these are guaranteed and protected by the Constitution, which is the fundamental law of the land. One point. On the other hand, it is also the fundamental because this is essential for all round development, such as intellectual, material, spiritual, etc. Well, initially, we had 7 fundamental rights. Let me read out one by one. The one, first of all, we have, that is the right to equality, which is under Article 14 to 18. Similarly, the second fundamental right we have, that is the right to freedom, which is under Article 19 to 22. And the third one, right against exploitation, which is under Article 23 to 24. And the fourth one, the right to freedom of religion, which is under Article 25 to 28. Similarly, the fifth one, the cultural and educational rights, which is there under Article 29 and 30. And, the right to constitutional remedies, which is there under Article 32. But we had one more right, that is the right to property, which was coming under Article 31. But it made a legal right under the 44th Constitutional Amendment Act of 1978, according to the Article 300A in Part 12 of the Indian Constitution. That's why currently we have 6 fundamental rights. That is the right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, as well as the right to constitutional remedies. And we are going to discuss all these rights one by one in a very detailed and the systematic manner. Well, if we basically look at, the features of the fundamental rights, the first feature that we have, some of the fundamental rights are available to only the citizens, while some other fundamental rights are available to both the citizens as well as the foreigners. This is one of the most important features of the fundamental rights that we need to remember. There are 6 fundamental rights. We know that. And all of these fundamental rights are mentioned under Article 12 to 35. Here we need to remember some of the fundamental rights are available to only the citizens, while some other fundamental rights are available to both the citizens as well as the foreigners. So now the question is, which of the fundamental rights are available to only the citizens Yes, the fundamental rights which comes under Article 15, 16, 19, 29 and 30. So the fundamental rights which come under these articles, these fundamental rights can be available to only the citizens. On the other hand, the fundamental rights will be available to both the citizens as well as the foreigners, except the fundamental rights which comes under except these articles, beyond these articles. That means the rights which is available to only the citizens will come under these articles, that is 15, 16, 19, 29 and 30. That is the fundamental right, the 15, the prohibition of discrimination on the basis of caste, creed, gender, religion, sex or place of birth. This is one of the fundamental rights comes under Article 15, and this this fundamental right is available to only the citizens but not the foreigners. Similarly, we have the opportunity of employment. So this is also one of the most important fundamental rights comes under Article 16, and this is available to only the citizens. Similarly, we have the right to freedom, the right to freedom of the speech and expression, right? So which comes under Article 19. That's also that is the right which is available to only the citizens. Similarly, the right which comes under Article 29, that is Article 29 and 30, it deals with the cultural and educational rights, and these two rights are available to only the citizens. That means here we need to understand the rights which comes under Article 15, 16, 19, 29 and 30. Remember very carefully, these rights are available to only the citizens, and except that which other rights are there, those are available to both the citizens as well as the foreigners. So this is one of the most important features of the fundamental rights. Now move on to the feature number 2, that is they are not absolute but qualified. Why? Because the state can impose the reasonable restrictions on them. Whether the restrictions are reasonable or not, it will be decided by whom? Yes, that will be decided by the court. So that's what we need to remember from the point number 2. So what's the feature number 3? We have they are justiciable. That is if it is violated, if the fundamental rights are violated, that the aggrieved person can approach the court. That means they are justiciable, allowing the person to move the court for the enforcement of the rights or for the infringement of the fundamental rights. Or if the fundamental rights are violated, then every individual has the right to move to the court for the enforcement of it. That's the feature number 3. Similarly, we have the feature number 4, that is these fundamental rights are defended and guaranteed by the Supreme Court. Since these rights are defended and guaranteed by the Supreme Court, hence the aggrieved person can directly approach to the Supreme Court and not by the way of appeal against the judgment of the High Court. Every individual, he has the right, he or she has the right to approach the Supreme Court directly and not by the appeal of High Court and not by the appeal of the judgment of the High Court. Since it is defended and guaranteed by the Supreme Court, so without going to the High Court, the individual, the aggrieved person can move to the Supreme Court directly for the enforcement of the rights. Well, we have the feature number 5, that is they are sacrosanct or the permanent. Yes, they are sacrosanct or the permanent. Here, this is one of the most important features that we need to remember. That means, you see, the parliament can curtail or repeal them, and not by the ordinary law, but the constitutional amendment the constitutional amendment law. Let me highlight this point in a very brief understanding for you. Well, according to Article 368, which is mentioned in Part 20 of the Indian Constitution, under this article, the Parliament has the power to change the existing law. The Parliament has the power to curtail or repeal the law. And that is what called the Constitutional Amendment Act. That means in order to exercise the power of the Parliament, what does the Parliament do? The Parliament under this article, that is 368 in Part 20 of the Indian Constitution, authorizes the Parliament to amend the Constitution. But it can amend the features of the Constitution, it can repeal and it can curtail the features of the Constitution. But one thing to be remembered here, without affecting the basic structure of the Indian Constitution. That means the basic structure of the Indian Constitution should not get affected. And without affecting the basic structure of the Indian Constitution, the Parliament can change the existing law. The Parliament can amend the Constitutional Amendment Act under this article, that is 368, which is mentioned in Part 20 of the Indian Constitution. Well, what are the different ways in which the Parliament can amend the Constitution? Let me tell you the three important ways, which is very simple to understand. The first one, it can amend by the way of a simple majority. That means the amendment can be done by the simple majority. Well, what are the features that can be amended by the simple majority of the Parliament? You see, the establishment of a new state, or the formation of a new state, alteration of the areas, boundaries, the emoluments, allowances, salaries of the members of the Parliament, the rules of procedure, language related matters. All this can be amended by the simple majority of the Parliament. That is by both the houses of the Parliament. So there are some features that can be amended by the simple majority of the Parliament. So what is such other way in which the features of the Constitution can be amended? Yes, the other such way is that there are some other provisions that can be amended by the special majority of the Parliament. So what is the special majority of the Parliament? You see, the features like the fundamental rights and the directive principles of the state policies, and all these features can be amended by the special majority of the Parliament. That is, the 2/3 members of houses, or the more than 50% of the Rajya Sabha as well as the Lok Sabha present and voting, and if with their consent, or if they do agree to change, if they do agree to amend the feature, then that will be amended. So that's what basically called the special majority of the Constitution. That means that features, there are some features like the fundamental rights as well as the directive principles of the state policy, which can be amended but by special majority of the Parliament. Similarly, the Parliament can also change some of the existing law. The Parliament can also amend the various other constitutions, but what's the method? That is the special majority of the Parliament along with the ratification of the half of the state legislature. So there are some certain provisions which is mentioned in the Constitution. Those provisions can be amended by the Parliament. No doubt the Parliament have been given the authority under Article 368 of the Indian Constitution, but also with the ratification of the half of the state legislature. That means with the permission or with the consent of the half of the state legislature, the Parliament can amend those the features. So what are such features? The features like the president and its election as well as its manner. Similarly, the legislative as well as the executive power, the distribution of legislative as well as the executive power, and Supreme Court, High Court, and all of these matters related to these things can be amended by the Parliament, that is by the special majority of the Parliament along with the ratification of the half of the state legislature. So what we are discussing here, I have said the feature, that is they are sacrosanct or permanent. That means the Parliament can repeal them, the Parliament can curtail them, under Article 368 of the Indian Constitution. That means the constitutional amendment can take place, but it can take place by the Constitutional Amendment Act, but not by the Ordinary Act. So in what way? What are the different ways in which the Constitution can amend the different features? The Parliament can amend the different constitutional features under this article. That's what I have said, by simple majority of the Parliament along with the special majority of the Parliament, and third one by the special majority of Parliament along with the ratification of the half of the state legislatures. Well, by these three ways, the Parliament can amend the features of the Indian Constitution. But, in 1973, in the Kesab Nanda Bharti case in 1973, the Supreme Court ruled that the Parliament can amend the Constitution under Article 368. That means the Parliament has been given the authority to amend the Constitution, but without affecting the basic structure of the Indian Constitution. So now you may have a doubt that what are the basic structures of the Indian Constitution? Yes, there are some features such as the supremacy of the Constitution, the judicial review, and the relationship between the national government and the state government, as well as the unity, integrity, sovereignty. So all these features which come under the basic structure of the Indian Constitution. So the parliament can amend the constitution, but without affecting the basic structure of the constitution, it has to amend the constitution. That's what it was ruled by the Supreme Court in the case of Nanda Bharti case in 1973. That's what we need to remember, my dear students. And the next one we have, that is, they can be suspended during an operation of the national emergency. That is, except the articles which is mentioned in 20 and 21. That means the fundamental rights which are mentioned in the various articles, except these two articles, the fundamental rights can be suspended during an operational national emergency. When the national emergency will be declared, then these fundamental rights will be suspended except these two articles, that is Article 20 and Article 21. So this is what we need to remember as the features of the fundamental rights. So let me give you a glance of the features of the fundamental rights. Let me highlight you this point so that you can get it very clearly. There are some fundamental rights which are available to only the citizens, but there are some other fundamental rights which are available to both the citizens as well as the foreigners. That means these are the fundamental rights which come under Article 15, 16, 19, 29 and 30. These rights are available to only the citizens, but there are some other rights which are available to both the citizens as well as the foreigners. Similarly, they are not absolute but qualified. That means the state can impose the reasonable restrictions on them. Whether the restrictions are reasonable or not, it will be decided by the court. Well, we have they are justiciable. That means they allow the person to move the court for the enforcement of the fundamental rights or for the infringement of these rights. Similarly, they are defended and guaranteed by the Supreme Court. Hence, they are defended and guaranteed by the Supreme Court. The aggrieved person can directly approach the Supreme Court and not by the way of appeal against the judgment of the High Court. Next one, they are sacrosanct or the permanent. That means the Parliament can curtail or repeal them by the Constitutional Amendment Act and not by the Ordinary Act. And that's what I have explained you everything in a very detailed description manner, that how the amendment can be done by the Parliament, what are the different ways of amendment. And the next one, they can be suspended during the operation of the national emergency. You can ask me that whether these fundamental rights, can these fundamental rights be never suspended? Yes, no. The fundamental rights can be suspended, but when? It can be suspended during an operation of the national emergency. When the national emergency will be declared, then only these fundamental rights will be suspended. But except these two articles, that is Article 20 and 21, the rights which comes under Article 20 and 21, except these two rights, and all other rights can be suspended during an operation of the national emergency. I hope you understood the different features of the fundamental rights. Now let us discuss the one by one rights which comes under Article 12 to 35. Well, initially I had said the fundamental rights are enshrined in Part 3 of the Indian Constitution under Article 12 to 35. But when each fundamental rights are described, that is, the 6 fundamental rights are described from Article 14 to 32. So now we will discuss that what does that Article 12 refer to. Basically, the Article 12, it talks about the definition of a state. So what are the definitions of the state? The state includes the various things. That means the state includes the government as well as the Parliament of India. That is the executive as well as the legislative organs of the union government. The state also includes the government as well as the legislature of the state government. That is, the executive as well as the legislature of the state government. Similarly, the state also includes all such local authorities like, the municipalities or the panchayats, the district boards, etc. The state also includes some statutory as well as the non-statutory authorities like LIC, ONGC, etc. And in this way, the definition of the state is defined in a wider sense. So the Supreme Court said that even a private body or the agency which is working under the state also falls under the meaning of the state. So that's all about. That means the Article 12 of the Indian Constitution talks about the definition of the state. Why? Because why did we discuss this Article 12? Because initially I said that the fundamental rights are enshrined in Part 3 of the Constitution under Article 12 to 35. So we need to remember, we need to understand that what is there in Article 12. So Article 12 talks about the state, and the state includes all such things like this. Now we will move on to the Article 13. So what does that Article 13 talk about? Yes, the Article 13 talks about the law. Well, the law is made by the parliament as well as the state legislature. So you see, there are some, Article 13 talks about the law. That means the laws which are inconsistent with or in derogation with the fundamental rights can be declared as void or null or illegal or or unconstitutional. So the laws which are inconsistent with the fundamental rights can be declared with can be declared as the null or void, if they found that that law is unconstitutional. That means these laws, there are some certain laws such as the permanent laws. These permanent laws are enacted by the parliament. Yes, the permanent laws are enacted by the parliament and the state legislature. Similarly, the temporary laws are enacted, the temporary laws which is enacted as an ordinances, as an issue, which is there is an issue which is which is ordered by the temporary laws, means the ordinances which is generally issued by the governor, generally which happens in the state government like this. Similarly, these permanent laws can be enacted by the central, the parliament as well as the state legislature. Similarly, the temporary laws, these temporary laws like ordinances will be issued by the governor. But you see, if any law, there are some laws, and if the laws are found to be violative of the constitution, then the judiciary has the power. That means, you see, the Supreme Court has the power under Article 32 of the Indian Constitution. Similarly, the High Court has the power under Article 226 of the Indian Constitution. Under these two articles, the Supreme Court or the High Courts can issue the writs against that one, and the Supreme Court or the High Court can declare whether the law is constitutional or unconstitutional. So this is what we need to remember. And one more thing that I want to highlight you on this point is that, well, you see, judicial review. So the power of this judiciary is what basically called the judicial review. So if somebody may ask you that, what do you mean by this judicial review? Yes, let me give you a brief understanding on this. The judicial review, suppose you see, the law-making authority or the law-making body is the parliament or the state legislature. That means, what is the function of the parliament or the state legislature? The parliament or the state legislature can make the law, but whether this law is constitutional or not, whether this is legal or not, will be decided by the court. So the Supreme Court, which has been given under the Article 32, and the High Court has been given the power under Article 226 that it can declare a law unconstitutional if it violates the fundamental rights that forms the basic structure of the Indian Constitution. And that power of the judiciary is basically called the judicial review. That means, what do you mean by just judicial review? The judicial review is the power of the judiciary that examines the constitutionality of the legislative enactments and the executive orders, and if they found guilty during this process, then that law will be declared as null or void or unconstitutional. So this is what called the judicial review, and we will discuss much more about the judicial review in the various in the upcoming lectures. I hope you understand that Article 13. The Article 13 talks about the law, or there are two types of laws, basically the permanent laws and temporary laws. The permanent laws are enacted by the parliament or the state legislature. Similarly, the temporary laws are enacted, issued by the governor, which is like the ordinances. The Supreme Court having the power under Article 32, and the High Court having the power under Article 226. It can confer the power to change the existing law, to change the law, or to declare that whether the law is constitutional or not. So this is what we need to understand from here. Further, Article 13 says that the constitutional amendment is not a law, and hence it cannot be challenged. However, the Supreme Court ruled in the case of Nanda Bharti case in 1973 that the fundamental rights, Article 13 says, initially Article 13 said that the constitutional amendment is not a law, and hence it cannot be challenged before the court. But later it could come to know that when there was a case of Nanda Bharti in the 1973, It said that the fundamental rights, that means the constitutional amendment is a law and it can be challenged before the court if it violates the fundamental rights, because that forms the basic structure of the Indian constitution. So I hope you understand it very clearly. Since it's since it affects the basic structure of the Indian constitution, so that can be challenged before the court. That means the fundamental rights, the law, the constitutional amendment, the amendment which affects the basic structure of the Indian constitution, then that can be challenged before the court. So the court can declare, so the court can rule over that, and the court can say whether whether that is constitutional or unconstitutional, whether the law is legal or not, and this can be declared only by the court. That's what under Article this 2, that is 32 and 226. Well, this is all about the Article 13, and in the next video lecture that we will discuss the various rights, that is the 6 fundamental rights which comes under Article the 14 to 32. We will discuss in a very detailed and the systematic manner, and I hope that I am very sure that I will make you very easy to understand each and every concept regarding to starting from the right to equality to the right to constitutional remedies, so that you can understand it when in a very detailed and the systematic manner. And I would provide you the detailed analysis so that you can easily elaborate the fundamental rights from Article 14 to 32. And thank you anyhow. Thank you very much for watching for this session. This is enough for today's session, and in the next video lecture that I will be discussing about, I will be giving you a very complete detailed description about the various fundamental rights in a very detailed and the systematic manner. And if you want to watch, if you want to see the next video, then I would request you to press the bell icon over here and subscribe to our channel for the latest notification. Thank you very much for watching.